make my submission?
What is the main plan?
Yes, yes. May I make my submission in a coherent manner for 10 minutes?
Just highlight, nothing more.
Yes, yes. Now, I am here and I would be using only two documents. One is a list of the finding of the learned single judge and the error thereon. And the second will be the written submission in more elaboration as to why that's an error. Now, the principal error are the following. Number one, that your lordship's has got a 17A situation here.
Is it about the validity of the consent itself?
Yes. It is about two or three things.
Or is it
First
is it about the scope, implementation, and the
no? So let me explain. Let me explain.
Article 163. What is?
Let me. I just started. Give me a few minutes.
I'll just take about 5 to 7 minutes after he has finished and give your lordships a gist of what the issue is. Let him finish.
So, as far as I'm concerned, for the appellant in item 20, my submissions are these.
Yes.
First, is that 17A has been completely violated. The requirement and mandate of 17A that there has to be a filter of a police officer has been violated, and despite that, wrongly upheld by the learned single judge. A private complaint, or any other complaint must go through the filter of a police officer is the first submission. And 17A has been completely violated. Here he has gone straight to the governor. Number two.
You need not. 2 years.
Number two. And this is a very large and a very serious constitutional issue. Yes. The law generally decided even by constitution benches till last year, Subhash decided, is that the governor is and must be bound by the aid and advice of the cabinet. Number two, there are well-known exceptions to it. It is not that he is always bound. One exception is if there is clearly...
In this case, whether it is a subjective discretion...
No, therefore, immediately, allow me...
Or constitutional discretion.
Exactly. Let me... Here, I am now coming to the exception. The exception is where there is manifest irrationality. Where there is manifest irrationality, that's the word in the test used by the Supreme Court, in the sanction, refusal, or order regarding sanction by the state government. Now, the learned single judge, on the contention of the other side, misreads that exception.
So, manifest irrationality in sanction.
If there is manifest irrationality in refusing sanction or granting sanction, then it is in the cabinet. Then the governor may interfere. That is the law generally. However, the learned judge upholds the sanction or the approval on the short ground. A, that the state government is an interested party. B, that if the chief minister heads the government, by definition, ipso facto and ipso jure, he must control the entire cabinet. And most important, even following the MP police judgment.
Broad outline of your...
No, I'm trying to... I'm not even taken 5 minutes, or even for a broad outline, I require 5-7 minutes. Because it's not the kind of case where I can encapsulate. But only I'll take 5 minutes, 5-7 minutes, because it's really important.
Yes.
Now, even as per the case, they have set up MP police establishment. A manifest irrationality is a test. Now, the learned governor's order nowhere points out or attempts to point out manifest irrationality. Nothing. What happens is a very strange thing. When the hearing is going on in the learned single judge, the governor or his office, without filing any counter, any pleading, files charts purportedly summarizing his file notings, showing that such a long note was made about the matter. First of all, charts are no substitute for pleadings.
Mr. Singhvi, don't stretch so much that it amounts to ex parte hearing.
Very well, I am interested only in one thing. If your lordship, very well,
broad general outline of your
very well, very well.
So, noted.
Yes. So these are the two broad heads. There are other.
Your appeal memo also, but it just we wanted to.
Yeah, very well. Therefore, let me, if your lordship, let me just put another point there very briefly. So broad heads are these. Give me 2 minutes, 2 minutes. There are broad heads are these There are other nuances which I'll not
Better
argue now.
Better in after holiday.
It is certainly not a case which does not require notice. If it has notice, your lordship will have a deferment of the 10th date. Nobody is running away anywhere. If the matter is so useless that your lordship did not issue notice, that's a different matter. But if your lordship is issuing notice or considering it, it is a balance of convenience and irreversible prejudice.
Undoubtedly,
Stares us in the face. That
Well,
the
my
10th
lord
should
is
defer.
saying, my lord, the Chief Justice is saying it's undoubtedly a matter for notice. You don't have to labor on that.
to be heard at
Yes,
reasonable
exactly,
length. There is
correct.
no doubt.
Well,
No,
your
Mr.
lordship,
Sibal, I'm
give me
not on
about
that. I'm
5
on the
minutes.
May I at
subsequent
least have
request.
one prayer? Your lordships may say it should be finally disposed of.
One supplement.
That would be,
May I make one submission?
it should be
I had
understood.
supplemented Dr. Singhvi before the learned single judge. Only two submissions. Number one, possession of the land was never handed over to Muda.
Not going in any.
No. That's a critical factor. Because the learned judge says
It will not be fair on our part, nor will be fair on the part of
the learned judge has recorded a finding.
the parties who are not present and who are subject to be noticed, yes, yet to be subjected to notice. So don't make elaborate submissions.
No, not elaborate. Only two aspects.
No submission.
Number one,
Without
layout was forum.
Without submission, we are issuing notice. What more you want?
Well,
We don't want any elaborate submission. Today we will hear it at length.
That there is not a whisper in the entire judgment. I have argued this proposition.
So we'll hear everything, every aspect of the matter.
There is not a whisper.
Second week of January, some date, my lord.
It is the foundation
week of
for the
January.
whole case. No
Around the
possession was
14th
taken.
or
Well,
second
13th.
week of January.
13th, Wallace. 13th.
13th or 14th. Oh, 13th is a Monday, my lord. I think
No.
Delhi lawyers would.
14th.
No, 13th is not a working day, sir.
Here.
No, Mr. Dave.
14th January, how can your lordships not be in Gujarat?
No, 13th is working.
I have left flying kites. I've given up flying kites.
In a
I'm
lighter
talking
vein.
13th, not
But in
14th.
something,
All in light.
Justice Shah used to make it a point to go. Justice M.R. Shah, his lordship then was. He
Any
used
day
to make it a point.
my
to-
lord, my lord.
I just want 5 minutes. I'm really forgetting about the merits of this matter. I tell your lordships, what is the real issue that arises in the case. And this doesn't apply to this government or that government. It applies to the constitutional position of the governor. I make a complaint against a minister, against the cabinet minister in the government of India or the state minister here. And the governor says, I give approval. Right, it can happen in any case, Mullahs. We can merely on a complaint, right, Mullahs? But under 17A, the word uses prior approval. Approval means approving something that has happened. Not a complaint. A complaint is an allegation. So the conspectus of the word approval. Otherwise, in every complaint, a governor in any state will order a prosecution. I'm sorry?
Approval to the inquiry.
Correct. I'm talking about approval. Any approval requires Mullahs approving something that has happened. Right? That exists. Now, in normal cases, it's an inquiry that has already happened and you give approval. In sanctioning matters, Mullahs, there is a whole set of procedures that go on, Mullahs. Forget this case. I'm just telling your lordships the broader issue. So, Mullahs, you have to have an approval of something that's already happened. But if the governor has the inherent power to order an inquiry on a complaint, that can happen in any case, by any minister in the country. Right? That's an issue not discussed anywhere. It's a real constitutional issue. That's number one. Number two, Mullahs, if your lordships will remember in Narsim Rao's case, Mullahs, before the constitutional bench, I myself argued it. Mullahs, the question arose that the sanctioning authority has to be the authority which appointed the person. That's because that's the authority that can remove him. So I argued that a member of parliament is not appointed by anybody. Not appointed by anybody. So who is the sanctioning authority? So because they could not find any sanctioning authority in the Prevention of Corruption Act under Section 19, so they said the sanctioning authority would be the Lok Sabha Speaker in the case of a member of parliament on the Lok Sabha and the chairman of the Rajya Sabha, because nobody else can remove him. Right? I'm sorry?
Speaker can remove.
No. Speaker will come to the conclusion that he is disqualified.
Disqualified.
That's right, after an inquiry. Therefore, he's no longer, that's why, because there's no statutory provision. Now, in this statute, it says sanction will be granted by the authority that appointed him, which also has not, this is a much larger constitutional issue. No, nobody appointed him. Nobody appointed him. So who is the sanctioning authority? It's the Legislative Assembly.
So according to you, the
Governor has no
Chief
jurisdiction.
Minister is not appointed by
It has no jurisdiction.
You are saying that Chief Minister is not appointed by the government.
No. I'm saying that to prosecute him, the authority concerned has been the authority. That's Section 17A. Just read it for a second. Just read 17A. These are very serious constitutional issues. See the last case. First, it is no police officer shall conduct any inquiry. Your Lordship has that? Or investigation into any offense alleged to have been committed by a public servant under this act, where the alleged offense is relatable to any recommendation made or decision taken by such public servant in discharge of his official functions as duties without the previous approval. The word approval means something has happened, not a complaint, not on a complaint. Right. Now just leave that. That's the one constitutional issue. Second, C, kindly see.
Yes. See.
In the case of any other person, because one is a government servant, Mullahs, right? So C will apply in the case of any other person of the authority competent to remove him from his office at the time when the offense was committed. Offense was committed when? In 2021-22. He was the leader of the opposition. He was not a chief minister. And who can remove him? Constitution bench says only the speaker. What jurisdiction does the governor have to even entertain this matter? Okay? Not decided by the single judge. Right? That's number two. Number three, another constitutional issue. In the Arunachal matter, Nabam Rebia, which again I argued, Murat, the court said that the governor has only three discretionary powers. What are those three? Number one, if a bill is sent to him, he can return it. He can refer it to the president. Correct? Under 356, the second discretionary power, he can say governor's president's rule should be imposed. He doesn't have to consult the council of ministers. Yes. And the third discretionary power is under the 6th schedule, 371. As your Lordship knows, that discretionary power was when he was governor in Assam, then extended to Sikkim, extended to Arunachal. He has certain discretionary powers under the 6th schedule. Other than that, he has no discretionary power.
Samsher Singh also said that.
Sorry?
Samsher Singh also.
Yes. Yeah, no, but.
Samsher Singh, the main first said.
Yes, but yes, that is different, Mullahs. Here they are considering Article 163, which your Lordship, my Lord the Chief Justice mentioned in the beginning, right? It's in that context that the court said, other than that, there is no power under the Constitution. Now, these are constitutional issues. This is not a matter, Mullahs, of A Chief Minister or B Chief Minister or A Minister or B Minister. It affects the polity of our country. And if you are going to prosecute chief ministers and ministers in this context, Mullahs, there will be complete chaos. I am not, Mullahs, supporting A or B, Mullahs, but this just cannot be done. So, Mullahs, these are issues that have to be decided.
Later.
Yes, that's all, Mullahs.
Therefore,
the issue. Therefore, Mullahs, we should all, it should not be that the writ petition gets decided, this becomes infructuous. Well, that should not happen.
So, Mullahs, therefore, I
don't want to say anything more than that.
Mullahs, before I was interrupted, I was trying to make a point without going into the merits. Would your Lordship give me 2 minutes to make that point in item 20? Can the Honorable Chief Justice hear me?
We are really not indulging into hearing of them.
No, I just take 2 minutes for saying something else. Your Lordship has rightly said that this is a matter deserving notice.
No, this is all loud thinking. Rightly or wrongly, we do not know, Mr.
No, Mullahs, I am only saying
This is all
I-
loud thinking.
I'm
This
only
stage when we are
saying-
considering issuance of notice, nothing more, nothing less.
Therefore,
No opinion
Malaj, if-
expressed, no merit is gone into. This
Right.
is all just
No, Malaj, if your lordship is issuing
this is the way
notice,
we converse and enjoy the conversation.
no, Malaj, I am saying something else. Allow me to say that, Malaj, 2 minutes.
Yes.
That is this. Malaj, the principles of balance of convenience and irreversible prejudice apply after your lordship issues notice. Your lordship is kindly considering issuing notice. All I'm saying is that there should be no situation where the balance of convenience is rendered irreversible. We are not, nobody can run away. It's only a deferment of 10th to January. Now, Malaj, if it is said that while your lordship is in seisin of the matter, my learned friends, the other side say no, and the matter goes on, then really, Malaj, the seisin of this Honorable High Court is being diluted. Heavens will not fall if the CBI court hears the same thing in January. That is the point I'm trying to make, Malaj. If it was a worthless case, frivolous, false, or vexatious, without constitutional issues, your lordships would not be entertaining it. But if it is being entertained, your lordship should consider that either by consent or by an observation, or I will make a statement here that we will move them. But there has to be some acknowledgement or recordal of that statement in the High Court. Otherwise, if the CBI court goes ahead, then it is really an exercise in rendering my entire proceeding infructuous or futile. That is the respectful submission. And your lordship does it routinely, for balance of convenience considerations in every case. Because ultimately your lordship decides in next month.
Your voice, sir, is not reaching us, Mr. Maninder Singh.
Lord, I was not. Lord,
Now, yes.
Lord, I was only making a humble submission. We are not joining issues. My Lord, your lordships have been decided to issue notice. My Lord, we'll assist your lordship. But my Lord, an order passed on 24th of September, only ordering for investigation. My Lord, these sides, my Lord, we will make it good, my Lord, that these are only colluding with each other to somehow get a interim order. So your lordship will just fix a date, my Lord. Matter finally needs to be heard. That's all.
It shouldn't be
One is
ignored.
asking for the other. By creating an artificial distinction, they are all hand in glove.
Lord, can I make one submission, my lord, with respect to the submission that was made for deferring the hearing of 10th of November? All that was told to your lordships, my lord, my learned friends can say it before the learned single judge. And the learned single judge, my lord, will take one view or the other on that matter.
We don't
There
want
is-
any legal advice.
My
We
lord,
don't want any legal advice
please,
from my learned friend. We
I'm-
know
I'm-
what to do.
my lord,
We
I'm
are
making
pleading before this honorable court.
my lord,
Our
I'm making a
difficulty.
submission to
We
your
don't
lord.
want any legal advice from
I am not giving you any legal
Sorry.
advice. Please.
So we don't want any legal advice.
I am
from
not.
you.
I don't
Sorry.
have the capability
We
to
are
do
not
that.
here to take any legal advice from you.
I am not giving you any legal advice. I am making a
Where he will resist tooth and nail, my lord. I can assure your lordships.
I-
And I'll come back again before your lordships.
very well. Whatever happens, my lord. All that was done by the
Multiplicity of proceedings. I don't understand why your lordship
My
should not
lord,
protect us.
my
Pending
lord,
appeal.
will
If
give
your
me the
lordships are
same-
inclined to issue notice, your lordship should protect us.
My lord,
Otherwise,
my
it becomes
friend will-
operation successful, patient dead.
My lord, my
No,
lord,
no, no, no.
give me the same.
What is the
courtesy.
point?
My learned friend will give me the same courtesy as extended to
Mr.
him.
Raghavan, if you want to drive us to more litigation,
Please,
we'll be happy.
Mr. Dave, let me have the pleasure of addressing the court without your interruption. My lord, all the times,
You
all
don't
the
want to fairly agree, Mr. Raghavan, that you will agree for deferment. Do you understand that?
My lord, no, I'm not.
And we know why.
I'm making it clear to my learned friend, I'm not giving any consent today. All that I'm saying, my lord, is the only order that has been passed in that writ petition is issue notice. What the learned single judge will do thereafter, he may even dismiss the writ petition, he may allow the writ petition, he may defer the writ petition, we never know. To therefore, my lord, to jump to the conclusion today, as my learned friend is saying, why should I face the CBI court? He's assuming that the court is going to refer to CBI. The court may dismiss my petition. We don't know. So therefore, my lord, I oppose any judicial order with respect to, my lord, deferment.
Raise the issue of competency, my lord.
14 Jan, man.
Just can it be 13th?
I have no problem on 13th, my lord.
13th?
13th.
Obliged.
Please,
Malad, the lead counsel is Dr. Singhvi. Malad, I'm just an appendage. His preference is.
Well, nobody dare call Mr. Sibal an appendage. That is being excessively humble.
He always has his own
Excessively
dates,
humble.
so we shall abide by his dictum.
My lord, whatever may happen between Mr. Sibal and Mr. Singhvi,
14th is a holiday.
we want both of them in our
14th is a general holiday in Karnataka.
15th.
13th.
13th is fine.
My lord, as I indicated, my lord, whatever may happen between Mr. Sibal and Mr. Singhvi, we want both of them in our court.
I think your lordships will
it's a
fix
big
it for 2
festival.
or 3 consecutive days. So give in
13th.
such a way.
So let us start on 13th, Mr. Dave. Let's start on
Well,
13th.
it's a big festival.
But
It's a-
Dr.
Yes.
Singhvi, let it be consecutive days. Otherwise,
No, I
there will be a
don't mind,
problem.
but let it start on 13th. No? Then there's a small gap after that.
Fine.
please.
No, about 15, 16, 17, 3 days we'll get. Because it won't be over in one day. Lord, large, unless your lordship separate me and hear me separate.
But I have some
great issues.
convenience of 16th and 17th.
Not 16.
I will enjoy the debate, but I am the sufferer.
No, but that's-
My lord, 16th and 17th, I have some difficulty. Can it be
Oh, God.
some date, my lord?
Then 2026 only.
No, well, then well, it's working. May I request for there's a working Saturday on 25th? We can start then. If it's going to the next week because Mr. Raghavan is not available.
21st would be more of.
Yeah.
Can it be on 29th and 30th if it is convenient to everybody, my lord?
No,
That will be too
25th.
far.
You all want continuous hearing? You want continuous hearing?
I would say
no,
so.
Mr.
I am
Dave.
entirely in your lordship's hands.
No, Mr.
for
Dave,
your
can I
lordships.
request?
Subject to the other side will be appearing.
Please.
Can I request? 25th is a working Saturday.
20th,
Any date, my lord. We will be here.
2-5
We will be here.
2-5 is a working Saturday. Mother, kindly consider that.
20th.
2-5, 25.
25 also no. 25 January.
Yes.
That will be too far off, Dr. Singhvi.
That's okay.
Then have it on 13th. You agree to either 13th or 25th at least.
And Mr. Raghavan is not on leave on 10th.
No, 13th. 13th.
It is all right. I am okay, my lord. I want to be